I'm Deputy Public Defender Oscar B. Rowe, and Dr. Fields has asked me to provide a lesson on California Penal Code Section 261, rape. The elements of this crime can be found in the criminal statute and the jury instructions in CALCRIM number 1000. Rape by force, fear, or threats. To prove that the defendant is guilty of this crime, the people must prove that 1. The defendant had sexual intercourse with a woman. 2. The woman did not consent to the intercourse. And 3. The defendant accomplished the intercourse by force or fear, which might include force, violence, duress, menace, or fear of immediate and unlawful bodily injury to the woman or to someone else, or future threats of bodily harm. Threatening to retaliate in the future against the woman or someone else when there was a reasonable possibility that the defendant would carry out the threat. A threat to retaliate is a threat to kidnap, falsely imprison, or inflict extreme pain, serious bodily injury, or death, or threat of official action. Threatening to use the authority of a public office to incarcerate, arrest, or deport someone. A public official is a person employed by federal, state, or local government who has authority to incarcerate, arrest, or deport. The woman must have reasonably believed that the defendant was a public official, even if he was not. Sexual intercourse means any penetration, no matter how slight, of the vagina or genitalia by the penis. Ejaculation is not required. Sexual intercourse means any penetration, no matter how slight, of the vagina or genitalia by the penis. Ejaculation is not required. To consent, a woman must act freely and voluntarily and know the nature of the act. A woman who initially consents to an act of intercourse may change her mind during the act. If she does so, under the law, the act of intercourse is then committed without her consent if 1. She communicated through words or acts to the defendant that she no longer consented to the act of intercourse. 2. A reasonable person would have understood that her words or acts expressed her lack of consent. And 3. The defendant forcibly continued the act of intercourse despite her objection. It is not required that she physically resist or fight back in order to communicate her lack of consent. Evidence that the defendant and the woman dated, were married, had been married is not enough by itself to constitute consent. Evidence that the woman requested or suggested or communicated that the defendant use a condom or other birth control device is not enough by itself to constitute consent. Intercourse is accomplished by force if a person uses enough physical force to overcome the woman's will. Duress means a direct or implied threat of force, violence, danger, or retribution that would cause a reasonable person to do or submit to something that she would not do or submit to otherwise. When deciding whether the act was accomplished by duress, consider all the circumstances, including the woman's age and her relationship to the defendant. Retribution is a form of payback or revenge. Menace means a threat, statement, or act showing an intent to injure someone. Intercourse is accomplished by fear, if the woman is actually and reasonably afraid, or she is actually but unreasonably afraid, and the defendant knows of her fear and takes advantage of it. I know this sounds sick, but a woman must be alive at the time of the sexual intercourse for the crime of rape to occur. The defense of reasonable belief in consent can be raised by the defendant. If so, the jury is given this instruction: the defendant is not guilty of rape if he actually and reasonably believed that the woman consented to the intercourse and actually and reasonably believed that she consented throughout the act of intercourse. The people have the burden of proving beyond a reasonable doubt that the defendant did not actually and reasonably believe that the woman consented. If the people have not met this burden, you must find the defendant not guilty. The defendant must continue to actually and reasonably believe in the victim's consent throughout the act. If the act of intercourse begins consensually and the victim then changes her mind, the victim must clearly and unequivocally communicate to the defendant her withdrawal of consent to the act. If, however, the defendant initiates the use of non-consensual duress, menace, or force during the act, the victim's subsequent withdrawal of consent to the act may be inferred from the circumstances and need not be expressed. People versus Ireland, 2010, 188, Cal.Rptr, 4th, 328, 338, 114, Cal.Rptr 3D, 915. The court has a sua sponte legal duty to instruct on the defense of reasonable belief in consent if there is substantial evidence of equivocal conduct that would have led a defendant to reasonably and in good faith believe consent existed where it did not. We all know that if you force somebody to have sex with you against their will, that is rape. And we have a common understanding of that. It's also considered rape in California. If you have sex with somebody who is unconscious and they're therefore unable to consent. For example, if you go on a date with someone and you go back to her place and she passes out drunk and therefore unconscious, and you have sex with her while she's passed out, then that will be considered rape. Rape, in my opinion, is one of the most egregious crimes someone can commit. It is also one of the most underreported crimes you will find. The rape, abuse, and incest. National Network, RAIN, estimates that 2/3 of rape cases are not reported. A big reason why rape goes unreported is that victims perceive that they won't be believed, or they don't want to go through the pain of a criminal trial. Oftentimes, the accuser's background is questioned. On the other hand, being falsely accused of rape is a serious problem. An example we use in this class is former NFL player Brian Banks, who, while in high school, was accused of rape by a fellow high school student who was attempting to cover up her absence from school. Despite a lack of evidence, Banks was convicted of rape and spent several years in prison before the victim recanted, resulting in him being exonerated. Accusers falsely report rape for a variety of reasons. Sometimes it's to gather attention. Sometimes it's because they feel rejected or slighted by the person who they make the accusation against. Sometimes there's a misunderstanding between the parties as to the issue of consent. Being falsely accused can ruin your life and reputation. As a public defender, it is my job to ensure the defendant receives a fair trial. Accusers falsely report rape for a variety of reasons. Sometimes it's to gather attention. Sometimes it's because they feel rejected or slighted by the person who they make the accusation against. Sometimes there's a misunderstanding between the parties as to the issue of consent. Being falsely accused can ruin your life and reputation. A suggestion, which is old-fashioned in today's highly sexualized world, is don't engage in sexual relations with someone you don't have an established relationship with. You can thank me for this advice later. I'm Deputy Public Defender Oscar B. Rowe, and that is your lesson on California Penal Code Section 261, Rape.